Good evening, learned friends, on the dais and off the dais. I am happy to address a gathering of lawyers and also non-lawyers who have come here to hear the discussion. I am reminded of what Prashant Padmanabhan once said, quoting an Australian Prime Minister, William Morris Hughes. He said he is a better Prime Minister because he was a lawyer. He said he is a better Prime Minister because he got very good number of practicing lawyers as his ministers and as members in his party. And he said he is fortunate to have very large number of lawyers on the opposition side because they never objected to a law which is good for the nation and were very objective and reasonable in their criticism of his policies. It is with this objectivity that we, the lawyer community, must approach any issue. It's all the more important when we discuss Supreme Court judgments. When I quote Sri Ramjat Malani and William Hughes, it is hard to ignore the criticism of our own learned Attorney General, Sri K.K. Venugopal, who came on TV and said that the Supreme Court ought to have understood the feelings of majority of people of Kerala before passing this judgment. The answer to this lies perhaps in the views expressed by Dr. Justice Dhananjay Chandrachud, I will call him DYC, D.Y. Chandrachud, in privacy judgment. Sitting in 9-judge bench, he wrote that a minuscule fraction of country's population constitutes lesbians, gays, bisexuals or transgenders, as observed in the judgment of this court in Suresh Toshan, 2013, is not a sustainable basis to deny the right to privacy. The purpose of elevating certain rights to the stature of guaranteed fundamental rights is to insulate their exercise from the disdain of majorities, whether legislative or popular. The guarantee of constitutional rights does not depend upon their exercise being favorably regarded by majoritarian opinion. The test of popular acceptance does not furnish a valid basis to disregard rights which are conferred with the sanctity of constitutional protection. The same principle applies in the case of Sabarimala. I would be discussing with you the legality of Sabarimala judgment in my capacity as a law student, just like each one of you. I have no other identity, believer or non-believer, Hindu or non-Hindu, man or woman, or supporter of any political ideology. It's all totally immaterial. I request the audience also to forget such identities because then only we can have an impartial discussion on the views of Supreme Court judges. Now it's a mistake to say that Sabarimala is a simple right to worship case. It's much more than that. Sabarimala case deals with deep interconnection between religious, social and public life in India and how discrimination within one sphere inevitably spills over to other spheres. Over the next half an hour, we will be discussing just the law on this subject. This is a judgment which uses more than 1 lakh words. DYC uses around 44,000 words. CJ Deepak Mishra and Justice A.M. Khanvilkar uses around 20,000 words. Justice Indu Malhotra's dissenting judgment also uses similar number of words. And the shortest judgment is by Justice Rohindran Nariman. He uses around 19,000 words. We cannot cover 430-page judgment in 30 minutes, but I will try to take you quickly through the origin of this case, the issues framed and the answer to those issues. I will try to demonstrate how the majority has arrived at this decision. I will also take you through the minority judgment of Justice Indu Malhotra and tell you how it is incorrect in my humble view. I will make you read some portions of Justice Dhananjay Chandrachud's concurring view. In my opinion, this is the most outstanding views out of these 4 separate views, as it has referred to the Constituent Assembly debates, CAD, in its proper perspective, discuss the issues of social exclusion and untouchability threadbare, distinguish an old Bombay High Court judgment in Narasu Appa, and held that personal law is not law within the meaning of Article 13 of the Constitution of India. Chandrachud refers to CAD 6 times in his judgment to show how untouchability has to be given a meaning by which the dignity of the individual is upheld. Indu Malhotra refers to CAD 7 times, but all those references are to show that untouchability is with respect to caste alone. The judgment of CJ Deepak Mishra and Justice Rohinton Nariman do not refer to CID at all. Ambedkar is referred 29 times in the judgment of Justice Dhananjay Chandraju, whereas in no other judgment Ambedkar is referred even once. I believe that made a huge difference in the quality of judgment of Justice Chandraju. Apart from what Sri O.B. Radhakrishnan, senior advocate, has told you, I will say that this case I would add that this is a case of utmost significance in our constitutional jurisprudence for the following reasons. 68 years after the advent of Constitution, the court held that in providing equality in matters of faith and worship, the Constitution does not allow exclusion of women. This is for the first time, at least one judge, DYC, applied the transformative role of the Constitution. The other judgment which applied the transformative Constitution being 377 judgment. Then, this may perhaps be the first time that the Constitution bench has recognized that social exclusion based on menstruation is unconstitutional. It also recognized that the intersectional discrimination, religious and social life are not mutually exclusive. Let us see how the case originated. It is narrated in the first paragraph of dissenting opinion of Justice Indu Malhotra. Petitioners inter alia stated that they learned of the practice of restricting entry of women in the age group of 10 to 50 years in Sabarimala temple in Kerala from 3 newspaper articles written by Barkha, Shravani Pandit and Veer Sangvi. The matter was filed in the year 2006. When the matter came up for hearing on October 13, 2017, a 3-judge bench consisting of the then CJI Deepak Mishra, Justice R. Bhanumati and Justice Ashok Bhushan passed the reference order. In the reference order it is cited, it is written, petitioners have prayed for issuance of appropriate writ or direction, commanding the government of Kerala, Devaswam Board, Board of Travancore, Chief Tantri of Sabarimala Temple and the District Magistrate of Pathanamthitta and their officers to ensure entry of female devotees between the age group of 10 to 50 at Lord Ayyappa Temple at Sabarimala, which has been denied to them on the basis of certain custom and usage. Then to declare Rule 3B of the Kerala Hindu Places of Public Worship Authorization of Entry Rules 1965. Now onwards we will refer to this as rules. Framed in exercise of the powers conferred by Section 4 of the Kerala Hindu Places of Public Worship Authorization of Entry Act 1965. Now onwards we will call this the Act as unconstitutional, being violative of Article 14, 15, 25 and 51AE of the Constitution of India. And Section 3 of the Act reads, these are enacted under Article 25(2). If you may refer, Article 25, subject to public order, morality and health, and to the other provisions of this part. You have to note here, Article 25 is the only fundamental right which is subject to all other articles, all other fundamental rights. Subject to the other provisions of this part, all persons are equally entitled to freedom of conscience and right freely to profess, practice and propagate religion. Subclause 2, nothing in this article shall affect the operation of any existing law or prevent the state from making any law, A, regulating or restricting any economic, financial, political or other secular activity which may be associated with religious practice. So there is a distinction between secular and religious practice. Then B, providing for social welfare and reform or the throwing open of Hindu religious institutions of public character to all classes and sections of Hindus. So Article 25(2) subclause B authorizes the state to make law for throwing open of Hindu religious institutions to all sections and classes of Hindus. Under this provision, Kerala government passed the Act, and under the Act, the rule is passed. Section 3 of the Act reads, places of public worship to be open to all sections and classes of Hindus, notwithstanding anything to the contrary contained in any other law for the time being in force, any custom or usage. So the words are important, notwithstanding any custom or usage, or any instrument having effect by virtue of any such law, or any decree or order of the court, every place of public worship which is open to Hindus generally, or to any section or class thereof, shall be open to all sections and classes of Hindus. Now, Section 4 reads, power to make regulations for the maintenance of order and decorum, and the due performance of rites and ceremonies in places of public worship. The trustee or any other person in charge of any public place of public worship shall have power, subject to the control of the competent authority, and any rules which may be made by that authority, to make regulations for the maintenance of order and decorum in the place of public worship and due observance of religious rites and ceremonies performed therein, provided that no regulation made under this subsection shall discriminate in any manner whatsoever against any Hindu on the ground that he belongs to a particular class. When the state of Kerala, in exercise of powers under section 4, passed the rules, Rule 3 of the 1965 rule is extracted in the reference order. It reads, the classes of persons mentioned hereunder shall not be entitled to offer worship in any place of public worship. So this carves out an exception. A reads persons who are not Hindus. B says women at such time during which they are not by custom and usage allowed to enter a place of public worship. So under the act, the rule is made. The act is made to overcome any custom or usage, but the rule says that if there is a custom, then it will be protected. Then other provisions are not important. That Rule 3, there are drunken and disorderly persons are not allowed. Some such exceptions are there. 1965 Act is passed in the Article 25(2), as I have told you. Then in the reference order, 2 amicus curiae were appointed in the year 2017. One is Mr. Raju Ramachandran and other is Mr. Ramamurthy. Paragraph 23 of the order is the stand of State of Kerala through Senior Advocate J.D. Gupta. Last paragraph 26 is where the issues are framed in this case. Now I will just read out those, there is no time, therefore I will just read out the issues and findings simultaneously. The issues and then findings of Chief Justice Deepak Mishra and A.M. Khanvilkar will be read out. Then I will read out separately Justice Rohinton Nariman and other judges. First issue was exclusionary practice based on biological factor, whether it is valid or not. The finding is it is unconstitutional. So the first issue is whether the practice of avoiding women, excluding them on the basis of a biological factor, whether it is constitutionally valid. Answer is no. Second is with respect to a doctrine which was followed by Supreme Court for so many years, whether essential religious practices, this is a part of essential religious practice of Hinduism, that women between the age of 10 and 50 should not enter Sabarimala. The finding is preventing women of certain age group is not essential religious practice of Hinduism. Third issue is whether the Ayyappa temple is a denominational temple. Answer is no. Fourth issue, constitutional validity of Rule 3B. It says it is ultra virus, Article 25(1). Fifth issue is whether the Rule 3B is intra virus the Act. Finding is it is ultra virus the Parent Act. Now, menstruation and religion is dealt with in detail in Justice Rohinton Nariman's judgment. Justice Rohinton Nariman agrees with the Chief Justice in his separate judgment. It says, the facts as they emerge from the writ petition and the aforesaid affidavits are sufficient for us to dispose of this writ petition on the points raised before us. I therefore concur in the judgment of the learned Chief Justice of India in allowing the writ petition and declare that the custom or usage of prohibiting women between the age of 10 and 50 years from entering Sabarimala temple is violative of Article 25(1) and violative of Kerala Hindu Place of Public Worship Act made under Article 25(2)(b) of the Constitution. Further, it is also declared that Rule 3B of the rules is unconstitutional, being violative of Article 25(1) and Article 15(1) of the Constitution. Menstruation and religion is dealt with in detail in Justice Rohinton Nariman's judgment. He narrates the taboo in various religions. It reads from paragraph 23, first sentence. In the present writ petition filed before this court, an affidavit filed by a Tantri of Sabarimala temple dated 23/4/2016 makes an interesting reading. Paragraph 10 of that affidavit is extracted. Everywhere when somebody takes on the vratam, either the women leave the house or take up residence elsewhere, or the men separate themselves from the family so that normal ashauchams in the house do not affect his vratam. This problem with women is that they cannot complete 41 days vratam because the ashauchams period will surely fall within the 41 days. It's not a mere physiological phenomenon. It's the custom among all Hindus that women during the periods do not go to temples or participate in religious activity. This is as per the statement of the basic tantric text of temple worshipping in Kerala, Tantra Samuchayam, chapter 10, verse 2. Affidavit then goes on to state that the Shastras forbid religious austerity by menstruating women. It will thus be seen that women are barred entry to the temple at Sabarimala because of the biological or physiological phenomenon of menstruation, which forbids their participation in religious activity. The second reason given is that young women should not in any manner deflect the deity who is in the form of a Naishtika Brahmachari from celibacy and austerity. At paragraph 24 of his judgment, Justice R. F. Nariman refers to menstruation and impurity in different religions. Paragraph 24. All the older religions speak of the phenomenon of menstruation in women as being impure, which therefore forbids their participation in religious activity. Thus, in the Old Testament, in chapter 15, verse 19 of the book of Leviticus, it is stated, "And if a woman have an issue, and her issue in her flesh be blood, she shall be put apart 7 days, and whoever toucheth her shall be unclean until the even." In the Dharma Sutra of Vasishtha, an interesting legend of how women were made to menstruate is stated as follows. Then Justice Rohindra Nariman extract the story, that is, Indra had a curse for killing a Brahmin, and then he divided that curse among women and told them that you bear that curse. Chapter 9 and 13 of Canto 6 of Bhagavad Purana is also extracted. That's also the same story. Also in the Quran, chapter 2 verse 222 states as follows: "Keep away from women during their menstruation and do not approach them until they are cleansed." In the Gospel of Mark, Jesus is said to have cured a woman who was ritualistically unclean. Equally, in the text relating to creation in Zoroastrianism, it is stated that a primeval prostitute called Jane, because of her misdeeds, brought upon herself menstruation. Here the learned judge is trying to show that religion had a say on menstruation. Some say it is a curse upon Indra, some other religions say it is a curse upon a prostitute. Justice Rohindra Nariman further says, however, in the more recent religions such as Sikhism and Baha'i faith, a more pragmatic view of menstruation is taken, making it clear that no ritualistic impurity is involved. Then he has referred to Article 25. It says that fundamental rights of all women cannot be denied. Now we will come to the dissenting opinion, which is most celebrated Justice Indu Malhotra's judgment. She discusses maintainability at paragraph 7.2. The right to move Supreme Court under Article 32 for violation of fundamental rights must be based on a pleading that the petitioner's personal right to worship in this temple have been violated. The petitioners do not claim to be devotees of Sabarimala temple, where Lord Ayyappa is believed to have manifested himself as a Naishtik Brahmachari. I have a comment to make. This is wrong in my humble submission. The very concept of PAL is that it can be invoked by anybody on behalf of any other affected individual or group. It is so from the times of Justice V.R. Krishnaiyer and Justice P.N. Bhagavati. It cannot be argued that for women's right, the petitioner should be a woman. For filing a case for LGBT, the petitioner should be an LGBT. Or for fighting for tribal rights, the petitioner cannot be an urban professor. Or for that matter, for filing a case for animal rights, petitioner can never be an animal. So this can never be so. This is the first error in my submission. Malhotra's judgment is a vision of group autonomy. At paragraph 8.2, Justice Indu Malhotra says, the right to equality claimed by the petitioner under Article 14 conflicts with the rights of worshippers of this shrine, which is also a fundamental right guaranteed under Article 25 and 26 of the Constitution. Here I have already referred to Article 25. The language of Article 25 may be seen. It says subject to all other provisions in this part. So that Article 25 is subordinate to Article 14. Both are not equal. On essential religious practice, Justice Indu Malhotra observes, it should be left to the believers and not for the court to decide what is the essential part of a religion. This is a departure from procedure, departure from precedent. So far courts have entertained that courts have dealt with the religious aspect and decided what is essential religious practice. But she is deviating from that. This is a welcome departure. This is also there in the judgment of Justice D.Y. Chandran. Now, at paragraph 10.6, Justice Indu Malhotra refers to some observations by Chief Justice Kehar in Shaira Banu case, Triple Talaq case. It is not difficult to comprehend what kind of challenges would be raised by rationalists assailing practices or different faiths on diverse grounds based on all kinds of enlightened sensibilities. In my humble submission, this is not proper language, because when a person approaches the court, either the court can entertain or it can disregard. This is not, this is something like a criticism of the people who are approaching the court. Then paragraph 10.30, judicial review of religious practices ought not to be undertaken as the court cannot impose its morality or rationality with respect to the form of worship of a deity. Doing so would negate the freedom to practice one's religion according to one's faiths and belief. It would amount to rationalizing religion, faith and belief which is outside the ken of courts. I have a comment. If it is purely religious practice, it is protected and stereotype them as being weak and lesser human beings. A constitutional court such as this one must refuse to recognize such claims. And then paragraph 56, though our constitution protects religious freedom and consequent rights and practices essential to religion, this court will be guided by the pursuit to uphold the values of the constitution based in dignity, liberty and equality. In a constitutional order of priorities, these are the values on which the edifice of the constitution stands. The stigma around menstruation has been built up around traditional beliefs in the impurity of menstruating women. They have no place in a constitutional order. These beliefs have been used to shackle women, to deny them equal entitlement and subject them to the dictates of patriarchal order. Here is the difference between the approaches of Justice Indu Malhotra and Justice Chandrachud. The word patriarchal order in DYC's judgment is important. According to DYC, the exclusion of women from Sabarimala is not simply a religious matter as Justice Indu Malhotra says. We will read those portions. In a civic as in social life, women have been subjected to prejudice, stereotypes and social exclusion. In religious life, exclusionary traditional customs assert a claim to legitimacy which owes its origin to patriarchal structures. Recognizing these forms of intersectional discrimination is the first step towards extending constitutional protection against discrimination attached to intersecting identities. In the dialogue between constitutional freedoms, rights are not isolated silos. In infusing each other with substantive content, they provide a cohesion and unity which militate against practices that depart from the values that underlie the Constitution: justice, liberty, equality and fraternity. The Constitution cannot allow practices, irrespective of their source, which are derogatory to women. Religion cannot become a cover to exclude and to deny the right of every woman to find fulfillment in worship. Then Justice D.Y. Chandrachud on ERP, essential religious practices, he has the same view as Justice Indu Malhotra. I don't want to read it. I will read his observations with regard to untouchability, because many people have this doubt whether this is similar to untouchability. Justice Chandrachud notes, reading Dr. Ambedkar compels us to look at the other side of independence movement. Besides the struggle for independence from the British rule, there was another struggle going on since centuries and which still continues. That struggle has been for social emancipation. It has been the struggle for replacement of an unequal social order. It has been a fight for undoing historical injustices and for righting fundamental wrongs with fundamental rights. This is what Austin also says. Fundamental rights chapter was framed amidst a history of fundamental wrongs. Then DYC observes, the incorporation of Article 17 into the Constitution is symbolic of valuing the centuries-old struggle of social reformers and revolutionaries. It's an attempt to make reparations to those whose identity was subjugated by society. Para 78 middle, the abolition of untouchability can only be fulfilled by dealing with notions which it encompasses. Notions of purity and pollution have been its sustaining force. In abolishing untouchability, the Constitution attempts a dynamic shift in the social ordering upon which prejudices and discrimination were institutionalized. Para 80 last portion, in the context of political freedom, Articles 14, 19 and 21 represent as it were a golden triangle of liberty. I would end my presentation with a quotation from Dr. D.Y. Chandrachud's judgment. He has quoted from Constituent Assembly debates. A member, Mono Mohan Das, has said this: "It's an irony of fate that the man who was driven from one school to another, who was forced to take his lessons outside the classroom, has been entrusted with this great job of framing the constitution of free and independent India, and it is he who has finally dealt the death blow to this custom of untouchability of which he was himself a victim in his younger days. Thank you all.